Welcome to the January 10th, 2018, a brand new year, Raymond Planning Board meeting. The board will come to order. We do have a quorum. I think I'm supposed to do that.
You can do that as much as you want.
Patricia?
Roll call.
Oh, I'm
Oh.
sorry. What
Okay.
roll call?
Tricia Beaton.
Sheila Burke.
Greg Foster.
Ed Kranich.
We also have Mary Quirk, our recording secretary. We have Scott.
DeVore.
Thank you. I got to practice on that. He's our code officer. Jim Seymour, our contract planner, and a special guest, Mary Costigan, our legal advisor. This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is said and to look at all of the exhibits that are present. Please notify the chairman if you are unable to hear or see. The board works from a published agenda and will be considered tonight, and we'll be considering tonight's items in the following order. First order of business is election of officers. Second is a workshop for which we have invited Mary Costigan, and we have planner communication and adjournment. We do not have 5 members, so we cannot vote on the election of officers. We'll postpone that till our next meeting. And where am I now?
Workshop.
Workshop.
I am the vice chair. As you notice that Bruce Sanford is no longer here. He has elected to resign. And so I'd like to thank Bruce. I think he said he had been here for 12 years as a member. And prior to that, I think he was a member for 2 years at some earlier point in time. And I don't know if any other members of the board would like to praise or make comments about Bruce's dedication to the board, but we will certainly miss Bruce. The first order of business, seeing that we do not have enough members to have an election, will be the workshop conducted by Mary Costigan.
Hello. So as we did this before, this is a pretty informal session. My job is to inform board members about your general duties under the law, specifically with regard to freedom of access and conflicts of interest. You have had this training before, so feel free to stop me if it's too repetitive. And really, this is more to, if you have specific questions that have come up, I'm happy to answer them, provided that there's not too much substance there and we talk more in hypotheticals. So let me start. We have, there's a general list of expectations for members on a quasi-judicial board that I like to read. It's just a list that gives you the kind of the broad picture. Number 1 is be fair, impartial, and unbiased. Number 2, don't let your personal feelings intervene. Apply the law as is, like it or not. You may interpret the law, but don't rewrite it. Listen carefully to all sides. Treat everyone before the board courteously. Explain your basis for your decision in writing. Decide based on the evidence before you, not on rumor, not on newspapers, and not on things that you gain outside of this room. Do not have contact with the parties outside of the meeting, and be sure to disclose any prior knowledge or relationships or personal gain from the application before you. So I'll talk about freedom of access first, and there's 2 main aspects that you should know about. One is public proceedings, and the other is public documents. So from the public proceedings perspective, when you have a quorum that meets, whether it's in this room or in the grocery store, it has to be noticed to the public because your transactions have to be transparent and open to the public. And the FOA and the requirement for public notice and the ability of the public to attend your meetings, to listen, is the reason why you should not have any meetings outside a publicly noticed meeting that usually occurs in this room, sometimes on a site visit. So you shouldn't be emailing each other as a group on a substantive matter, because that then is considered a meeting. You can email about, hey, are you available on Friday at 3? Yes, that is perfectly fine. But if you're talking about a substantive matter that's before the board, it has to be in public and noticed. If three of you run into each other in the grocery store, you can talk about the weather and what a nice day it is, but you cannot be talking about the project. If you want to have a site visit of the property, certainly the best way to do that, if you're doing it as a group, you have to notice it, and members of the public can come on the site visit. It certainly is best to do a site visit as a group and as an organized manner. If you miss the group site visit, or you happen to want to go on a site visit by yourself, you can't be talking to the applicant while you're at that site visit. You can drive by and take a look. But you should come back to the next meeting and say, hey, I missed the site visit that was scheduled. I went by myself on Friday, and I just explain on the record what you did. You drove by, you parked in front of it, you looked, and so for the record, so everybody knows what happened. It is discouraged to do that. I'm not telling you to do that. It's discouraged to go and do site visits on your own. I think the only time is when there's a group site visit and for some reason you can't make it and you really think that it would be beneficial for you to just kind of see it on your own. But don't go make your own decisions and go on site visits, especially if the rest of the board isn't going, because that causes problems about everyone working off the same material. I'm trying to think of other things about the meeting. Really, it should just be noticed, and just don't talk about it outside the record. The other thing about FOA is taking minutes of your meetings, which you take care of and you know how to do that. Executive sessions usually don't apply to this board. The only time that you would have an executive session is if you had a really contentious application before you, and you had, I can remember one, and you have lawyers on both sides or lawyers on one side, and they're making legal arguments, and you're really kind of stuck, and you want to know what your legal rights and responsibilities are and want some legal advice, then we can go into executive session, and I can talk to you about that. A general legal opinion about a substance what people are disagreeing about, that's a public thing. But if it's something that should be a confidential communication between attorney and board, that's okay for an executive session. But that's a really rare occurrence, because usually the legal opinion is out in the open in front of everybody. You have the benefit of Jim, which is great. So in terms of your written decisions and your record, he does a good job of taking care of all of that. So that's also another part of a public proceeding, is the written notice. It's really important in your written decision to, even if you're approving everything and each condition, you should still go through each condition. What's most important is if you're denying something. The most important thing is if you're denying an application based on one provision or two, you have to be really, really clear about why. It can't just be you didn't meet that. You have to say why, so the applicant knows why they were denied, and if they happen to appeal, the court knows why you made the decision that you did. So in a written decision, it becomes really important, number one, when there's a denial. Also, number two, when you're granting an application and there's a lot of opposition that you think may continue to go further. A written decision is not just for the applicant, but it's also for the judge and the lawyers in the future. It really is, because the last thing you want to is for something to go to court and get sent back just for you to make new findings and then go back up, because that's just a pain in the neck, and nobody wants to have to do that. Okay, so that's public proceedings under FOA, and then there's public records. Generally, everything you receive, review as a result of your work here at the town, everything you write, all of your emails, all of your notes that you keep are public records. And so anyone at any time can ask to see those. So they should be retained in a manner. You should generally keep your emails in a separate email account, where you know that that's your kind of your town emails. Even if you have your Gmail, you should have a folder with all of your town stuff that you just file away. So if there is a FOA request and someone says, I want all of the emails sent to the planning board between September 1st and of 2017, and so you can just go to your email and you can pull it out and you can just send all of them.
Even when we get like, the meeting minutes are in the mail, that
Just
kind of stuff?
No, just the substantive
Okay.
stuff. Yeah.
We don't really do that by email.
Yeah.
So.
And then so then you have to be just mindful of all of your written communications and mindful of keeping those records. I also get questioned of, okay, we're on a planning board. We have, sometimes we get a stack of documents like this. Do I have to hang on to everything? No. The town will hang on to kind of the master file. But at the end, unless you have some important notes or something, you can recycle all of that stuff. You don't have to have a stockpile at home because it will be on the town files. Okay. Any questions about FOA? Freedom of access? I mean, there's a freedom of access officer. Do you know who that is in Raymond? So the requests will go through the town clerk, and then the town clerk would get in touch with you if you were the holder of documents that would be responsive to the request. So that's how that would work.
And those documents might be like these notes that
Yeah.
I keep. Yeah.
Yep. It generally would be associated with a particular application, and it would be, I want to see all of the notes from all the planning board members that they kept in X application, and all the emails. Usually somebody's looking for something, right?
Yeah.
They're usually pretty specific.
They're pretty specific. They think, something went awry, that, they think that you had some sort of email communication with the applicant when you shouldn't have. So they're going to ask for all of your emails. And, by process of elimination to see that there isn't one like that, then, so you usually know why they're asking for it. But, yeah. Did you have anything to add?
No, I'm just going to say that most of the time it's, like she said, it's usually communications about materials that have gone back and forth, and in the hopes of finding either an ex parte communication or some kind of opinion that might have been biased in some form or format.
Yeah.
Very rarely does it ever come out that way. Oftentimes it's just to see the mirage
Yeah,
of
they're
paperwork
looking
and
for the
everything.
smoking gun.
Right.
They're looking for that email that says, I really hate this applicant. How can we deny this? Okay, so now conflict of interest. There is, and this generally covers when you should and should not be sitting at this table for a particular application. Most of the time, it's going to fall in that really gray area. The first one I'll talk about is the really clear black and white, which is the personal pecuniary interest that is actually in statute that requires recusal. And the conflict situation is when the official is an officer, director, partner, associate, or stockholder of a private corporation, business, or other economic entity, which is the subject of the issue before the body, and the individual is directly or indirectly the owner of at least 10% of the stock of the private corporation, or owns at least 10% interest in the business or other economic entity. So if you own a business and they come in with an application, or you own 10% of that business and they come in with an application, you have to recuse yourself.
And just an FYI, another document we passed out to you this evening is our planning board bylaws and rules of conduct. And actually on page 3, hers went into a little more detail into the pecuniary interest. Page 3 and page 4, it lists all the different
Okay.
versions of conflict of interest that we may get into, so.
Thank you, that's helpful.
If a board member believes that it's necessary to recuse themselves from a certain
It's
item
in
on the
the
agenda,
bylaws there, yeah.
how do we, or do we have to explain why? Or can I just say, well, this item is, I have a conflict and I'm going to sit in the audience?
Well, you typically, don't they bring up their potential, their conflict, and then the board decides if they feel that it's,
Yes.
or can they actually just say
I'll
no?
give an example. There was an issue involving Luneco Land Trust, and it was a minor thing, but I'm heavily involved with that organization. I'm on the board of that organization, so I brought that up immediately, and based on the issue before us, they said, no, that's not a conflict. So I would think that if, for a privacy reason, you don't want to get into why you think you have a conflict, that it's perfectly fine just to say, I recuse myself. If you think it's, and you want to discuss it, I think that's
Yeah, I think if the
appropriate.
individual are strong enough feeling that they really have a conflict, then probably the rest of the board's going to say, if it looks bad,
Exactly.
it might be bad. It's probably better off having that person
Exactly.
recuse themselves. But if they're on the fence, they say, well, I took my car to XY garage, and, and he's one of the applicants here tonight, but I really don't have,
An interest in
an
it.
interest, then,
Yeah.
So, yeah, so your question went to that kind of gray area. This, just backing up, what I read is just the very clear pecuniary interest. You have to, that's not, I should amend that for you, 'cause it's
well, I was going to, there's a few
pecuniary.
things in here that we, yeah.
Because that's not quite accurate, but I can help you with that.
Okay.
Um,
This is old, too.
Yeah, so in the gray area cases, what you do is you raise it to the board and you say, I don't think I should be, there's two situations. One is, I'd like to recuse myself because I have X situation. And then, or the alternative is, I don't really think I need to recuse myself, but I just want everybody to know that this is the situation. And in both of those cases, the board then votes on whether or not you should recuse yourself.
So it's done during the meeting when you have the
Prior to the
item brought up.
discussion.
Yes.
Okay.
Yeah. And so it should be disclosed why you are recusing yourself.
I used to serve on a board
If you don't
in
want to,
Wyndham.
just don't come to the meeting.
I used to serve on a board in Wyndham, and oftentimes my company we'd be representing in the town. I would often say I have a conflict of interest, and they'd agree, because obviously I have an interest in my company succeeding, so there'd be immediate conflict there, so I just go sit in the audience and be quiet.
Yeah. And usually it has to do with relationships. That's my sister, that's my brother, and you're going to recuse yourself then. But then it's the gray areas are, that's my sister's ex-boyfriend, or I used to work for them, or and when in doubt, disclose. It should always be, the default is disclosure. Even if you think there's no way it impacts your decision making, you should still disclose.
And again, as a public body, my experience over the years is it doesn't really have to be a slam dunk conflict, but if it smells a little funny for the eventual decision of the board to be on public record that could be challenged, you don't
Right.
want any
You
taint
don't want it. No, right,
associated
exactly.
with it at all.
Yeah. So the other part of conflict of interest is bias. And bias comes into play when somebody says, you know what, you walked into this room hating my project, and it didn't matter what the information before you said, you were going to deny this anyway. And so your task when it comes to bias, claims that could be made, is number one, don't express any opinions of predeterminations. Really only base your decision on the information that's in front of you. And be transparent in all of your transactions. No ex parte communications, meaning no communications with the applicant or any strong opponents to the project. If they call you, if you get a call, I was just involved in a situation. If you get a call from someone, either an applicant or an opponent, and they say, I want to talk to you about this application, say, I'm sorry, I can't talk to you, thank you very much, and you hang up the phone and be very polite. Or, hey, can I have coffee with you and talk to you about this application? A lot of people don't know that they can't do that. They think that you're like a Board of Selectmen member and they can lobby you and talk to you, but you're not like a Board of Selectmen member. You are on an adjudicatory body, and you're a decision maker, and your decisions impact people's property rights, and so you cannot have ex parte communications. You also cannot be bringing outside information into your decision-making process.
And this is the one that probably we face, is that people bring either their expertise or documents, and they try to inject that opinion into part of the decision, and oftentimes we try to say, don't do that. And I think the board needs to understand is that if you do have information like that, it should be shared through the staff so that we can distribute that back out to everybody on an equal basis, because you holding that information, I believe, creates a form of bias, right?
It does, yeah. And so, and if you, so say you're looking at an application, you don't really, you know, there's some complicated thing about phosphorus, and you're like, what in the world is that? And I don't understand it. Don't go home and get on Google and do your own research and come to a conclusion about this application based on what you find there. Tell Jim you don't understand it, and that at the next meeting you need him to come back and provide you with more information so you understand it. And so he can explain to you whether or not this application meets that standard. Even if you did come across some information, which you shouldn't, but if you happen to, and you think it's important, then you bring it to Jim or Scott and say, I think this is important. But really, you're the decision maker. You're not gathering evidence outside the record. It's the staff's job and the applicant's job to be providing you the evidence, and your decision is based solely on that stack of documents that's in front of you and what people have said. You can use your own expertise and knowledge, because you can't ignore that. I mean, if you understand phosphorus better than anybody else in the room, you can ask those questions. You should be open about it. But it's still, you're forming your opinion based on what's in front of you, not based on, you're analyzing the information in front of you based on your knowledge, not analyzing information outside of the record based on your knowledge and bringing it into this room. So that's the difference. If you believe that there is an applicant or an opponent that thinks that you have a bias, you may want to, on the record, say that it's my understanding that, you know, some may believe that I hate roller coasters and you're trying to build this roller coaster. Just for the record, I might hate roller coasters, but that's not influencing my decision whatsoever. I'm looking at the information that's in front of me. Everything should be geared towards being open and transparent, and not looking or acting as though you have a decision predetermined in your mind that no matter what's in front of you, it doesn't matter, that you're going to decide a certain way based on emotion, based on opinion, based on what have you. And if you really think that your opinion is so strong that you can't make a fair decision, you shouldn't be sitting at this table. It's not fair to the people at the table with you, it's not fair to the applicant, it's not fair to the town. So that's another disclosure that you can make, and if you want to recuse yourself based on that, you can.
If someone has specific knowledge in an area, worked in construction my whole career, so I've
Yeah.
worked in a lot of different areas. And sometimes I'll have an engineering opinion on something that's before us. For an engineering evaluation, can I put that out there, or?
Well, you probably want to word it in the form of a question,
And
and then ask
the
staff
question
if,
should be directed to you or to the chairman?
typically, it
Most
depends on where you are. in the
communication's supposed to go through the
You should also go
chairman.
through the chair. I would, if you're in an open discussion, you're obviously having it with the chair and the rest of the board members. But you could say, you know, I have some concerns with the, say, the structural integrity of this wall. I think the board should, you know, invest in a third-party opinion, looking at some of the engineering principles for this. I think that's perfectly fine. And then the board can have a discussion whether they agree or not.
Right. So your decision needs to be based on the evidence in the record, right?
Right.
So if you have evidence in the record and it consists of an engineering opinion, a structural engineering opinion provided by the applicant, and that structural engineering opinion says, totally sound, totally great, this is gonna happen.
No, if he's a
And
professional
you-
engineer, I'm not gonna dispute it.
But it,
He has that
just
right.
say, if you disagree with it,
Yeah,
your opinion is not evidence.
Right.
So if you were to make a decision to deny it because you disagree with that, that would not be proper because your decision is not based on the evidence in the record. So in order to get evidence into the record that may or may not support your opinion, if you're just looking for another opinion because you have a different one, that's when you would say to staff, you know, I'm not quite so sure about this opinion that they've provided. I'd really like a peer review of that, and you're more than welcome to do that. And then that's how you would get, if you're right, and that's really not the right conclusion, you could get a peer review of that, and then you'd have that additional evidence in the record.
what resources does the board have? Do we have access to a civil engineer that could send questions to, or? That's
Hello.
you?
It's me, but I'm not a structural, in the case of a structure, we'd go to another third party.
Yeah, but you
I
have
could-
the ability to
I could
ask
give
for a peer
examples,
review.
but I don't know
Right,
if
and I
that-
think
if you
most of the
want
time in the
that.
cases that Ed may be thinking about is cases where maybe the structural information is absent
Yeah,
in some cases.
we
or-
did have
Yeah.
one like that, and it
And,
was
you know, the
regarding the
board will
wall.
put a condition on it, and then it kind of gets passed down to the code enforcement officer to make sure that all the structural analysis has been appropriate for the permit.
Yeah.
So
Okay.
we handle it a couple
Yeah.
different ways. But in some cases, if you think it's a matter of life and safety, that's appropriate to bring up as
Yeah.
part of your decision, because that's one of your.
Jim, the
And
other
if you-
thing
yeah.
we've talked about in the past is like, if, anytime you run into something like that, we get our materials in advance.
Mhm.
I would give you the advice, this is what I do, is I'd call Jim and say, this
Okay,
is
so-
where I'm coming from, I have some issues here. How do you suggest I handle this particular thing at the meeting?
Right.
And he will give you that advice.
And if
Okay,
you,
so I could pass a communication on to
Correct.
you
Yeah,
outside.
I was gonna say, staff is
everything,
here to support you.
Okay.
Right.
yeah,
Good.
But
It's not
also-
ex parte
right.
if you talk to me.
right.
Or you
Also,
have a
yeah.
question about something, or you think something's missing, you can say, well,
Right.
where are we with this? What will happen in this procedure?
Yeah.
And like I said, we'll either say, well, we typically handle that at the building permit level, or if it is a larger structure, we could say, yeah, it's appropriate, maybe we do have and we'll bring it up to the board.
Yeah, if you have, if you don't feel you have enough information in front of you from the applicant, you can certainly ask the applicant to provide more information. And if they say, I don't want to give you a structural report, then you say, well, I'm going to have to deny your project.
Mhm.
That's the choice you have.
Mhm.
So they can certainly be asked to provide more information, and if, you know, you shouldn't feel that you're required to make a decision based on just what's in front of you. It has to be a reasonable ask, but it can be an ask.
I mean, most of the time, everybody just wants the assurity that it's meeting a certain code or a certain,
Right.
in your
It has
case,
to
you
be
know, safety
related,
concerns,
yeah.
considerations, that something's not gonna fall over, or it's gonna stand the test of time.
Right.
You know, again, there's this level, then there's another level too, and they come in for a building permit. And a lot of times, some of these analysis will come forward when they come in for the building permit, and they'll review that
Yeah.
piece of it.
Yeah, the other part is it has to be related to a standard that you're reviewing, of course.
Right.
Other questions?
on that.
That's just like the broad general, your responsibilities as board members to the public and to yourselves and the applicants.
We do have one other question for you, but I think we'll hold on for 1 second. As I mentioned, we did pass out the bylaws. These were last updated in 2014, and I think it was just a tweak. And you can see the amendments have been on this, like 4 of them since '99, and Mary's already pointed out that we probably need to update
I would update the conflict
the
section.
conflict section, and there's probably some other sections that we may need to update. And again, these are your bylaws, so these can be updated at any point.
Right.
Typically, we suggest every couple of years we go through these just to make sure there's no new statutes or anything like that. I do have a question about that one. Is that true?
He's pointing to the last one that's
On page
section
5.
that says the planning board may delegate any member of the town's staff as their designee. I can't imagine that is accurate.
It's on page 5. I saw that tonight, and I'm
Yeah.
like, wow,
Oh, boy.
don't
You're
get
going
used
to
to
have
that
some
one.
fun
I can see a
now.
line going through that one immediately. But for the most part, I don't know.
Was
Again,
that something we'd ask Mary to review
I
in
think
terms of it?
well, you have a copy of it, and obviously
Right.
you can go through it, and if you
Right.
have questions, this is an open document, we can kind of go back and forth, but
Okay.
Yeah.
we probably should have Mary just go through, because a lot of these do get into some of our procedures and protocols.
Well, and stuff changes,
It
Yeah.
does change,
I think what might be helpful is if you go through them, have either questions or changes that you want to make, and then
And then
I
you'll do
can
a
go
review.
through it, and I can do a review, and I can make the changes that you're looking for.
Okay.
but I mean, for a lot of the conversations, a lot of things that she's discussed, how and notifications, all that's spelled out in here. Unfortunately, I just don't know if all the board members ever got a copy of this or not. It's actually one of the better documents as far as understanding how the board should act, and everything goes through the chair. It just
Yeah.
lays out everything about how the hearings,
Yeah.
the roles of the vice chair and the chair, and again, goes into here even a little bit about evidence and
Yeah.
just how the whole meeting is supposed to go, Robert's Rules of Order, those
Right.
types of things. And I think that, we've gone through a few chairs here, and we may go through a few more, but it's just important for continuity to understand, how
Yeah.
you all are supposed to interrelate anyway, and be professional about this, so that things just don't get chaotic or even dragged out, because
Right.
that's the other side
Right.
of this, is that, we all kind of get going here, and we're like, we're out of order.
Yeah.
Pull it back in.
Right. Yeah. That's a really good point. There are. There seems to be something in the water lately of some not so civil discourse in some public proceedings. And so I actually recently met with folks at MMA looking for some ideas on that subject in terms of training and giving board members the tools they need to control meetings and knowledge as to when they can silence someone in the audience and when they can speak and how much they can control them. It doesn't happen at planning boards as much as it's been happening at select board meetings all across the state. But well-written bylaws and a well-written structure for your meetings is really, really helpful. And so I'll look through those with that in mind. Just everyone's allowed to speak, but everyone's not allowed to speak for a half an hour.
Right.
If you give everyone the same time to speak, if you have a whole room full of people, everybody gets 3 minutes, 5 minutes, whatever you want to do, but that's it. They get to speak once. It doesn't become a back and forth. You don't let people pop up, and you put real order to it and stick with your process, and then their due process rights are not
Mary, I
violated.
think one of the challenges that we faced as a board is not so much with our applicants, quite honestly, but it's with how we interact as a board.
Okay. Yeah.
And, that the preparation for the approach to a meeting by the chair and the vice chair, just in case, I think becomes so critically important that you have we clearly know coming into the room, yes, we have an agenda, but within that agenda and an application, this is how we do it.
Right.
You know, on an initial application, we're going to do this, then we're going to do that, then we're going to do this. At what point do we decide an application is complete? At what point do we entertain waivers? I think that, for me, like, our last two chairmen went at that real different. And I confess that I kept going back to the earlier chairman saying, you know, no, don't start there. You got to, you know, can we come back to what's specifically before the board? I think that's one of my questions, focusing on the item that is in front of us.
Right.
So, for example, when we're in a second go-around with an applicant, so much of this has already been resolved, discussed,
Sure.
and usually we're now down to waivers and conditions. Well, we've agreed that they meet X, Y, Z, A, B, and subsection whatever. And sometimes I feel like we circle around old ground, you know, and, you know, I've got to admit to some frustration with that. And I'm not sure how I want to advance the meeting, yet at the same time, I want to make sure we're doing it right. But do you know, when do we just, what's the approach? I mean.
Right.
And I think a lot of that is in the bylaws about, but to your point, it doesn't necessarily spell out, you know, do we go through this, then jump to the waiver for that thing? That whole order is, and that often is kind of at the control of the chairman.
Right.
And I understand the last two have had different styles in the way they do that. I think more importantly, just the matter that you do go through that process.
Right.
I don't know if the order is.
I mean, it's really, it's project specific,
Right.
really.
It is.
You
It
know,
is, right.
I think that some of it could be driven by Jim and the way his reports are written, and you could, you know, you just follow it that way. I think you could rely, sorry, Jim, I'm putting all this on you.
Thanks.
But you could, I mean, because it's project specific, you
Right.
could rely on Jim saying, you should, because it makes sense, you know, it usually makes sense to look at this first and then figure out a waiver, because if you're not going to give them that waiver, it's not worth going to the next thing.
Well, it gets complicated
So-
because we have so much shoreline zoning in town that we have dual applications going.
Yes.
And so the waiver may correspond to the site plan as well as the shoreline zoning criteria. So that always becomes chicken, egg kind of thing. Which one do we want to
Yeah.
dive in first?
Like we had, in the last one, it was the street ordinance
Shoreline.
and private road,
site
and it
plan.
was all,
Yeah.
you know, so
Right.
we had a number of different sections to go through.
Right.
But I have to say, and, you know, everybody else jump in, that Jim, in particular, since our last transition, has been very thorough and, okay, this is kind of what we should be doing, and, how, you know,
Right.
he's always very nice. You don't have to follow this, but my recommendation would be.
Yes. Yeah. And to
Yeah,
your
watch
point,
out, we
yeah.
have designee authority, you.
And to your point of trying to stop rehashing everything else, it's good to take straw votes as you go along. So you can say, okay, we put that issue to bed.
Right.
You know, 4-2, we like it. It's good. We're done.
Okay.
Until you actually have a vote, you can always have somebody say, you know what, I was thinking about issue X and I'd like us to, I want to reconsider my vote because I have a question on it. But if there isn't something like that where someone has changed their mind, that should be put to bed. You voted on it, you're done, and Jim can keep record of the straw votes as you go along.
And some of them are so small that we may even just group them all in as one big motion.
Oh, right,
you
yeah.
know, and that we've done
Right.
that as well, and that helps
Yeah.
move things along as well. We've
Okay.
talked about that as, you know, how we can keep things. But, you know, again, that's kind of the role of the chair and the vice chair, to kind of checks and balances, to kind of keep things moving, because you don't want to get caught in this wordsmithing, going back and forth,
Right,
minutia,
right.
and rehashing it over and over again. And we can get caught up in that. We're all
Yeah.
technically minded. It's easy to get pulled into that. But sometimes that's why the chair might just nudge the vice chair might nudge the chair and say, let's kind of, you know, keep this moving. So you're a team as well as a, a
Okay.
board.
Does anybody have, I wrote down some questions, so I don't want to take the whole floor. Does anybody else have questions?
I had one question with regards to what is appropriate to talk about outside of the public meeting.
Mm-hmm.
For instance, the board itself, the composition as far as the elections. Can we talk amongst ourselves outside of the public hearing with regards to that?
Not with regard to who you want. Only, on X meeting, we're going to be considering, the slate
Well,
of,
but how do you develop a slate if you can't talk to each other
Right.
you talk to each other here.
in full public view?
Yeah.
Okay,
Okay. Like,
Yeah.
all right.
Because it's still the town's business.
I get you.
Who is going to be chair, vice chair is the public.
Oh, that
That's
part.
the public's business.
For sure.
Yeah.
I'm more referring to like questioning somebody as to their comfort level or that sort of thing. Like, to get their opinion as to their being comfortable or knowledgeable enough, or
So
uncertain.
you want to put up somebody's name for chair, but you want to do that if they're not comfortable with that.
Exactly. Like when you
If
on
it's-
a
you can
on
have
a
a-
personal level.
You can have a two-person conversation. You can't talk as a group.
Right.
Okay.
You can go directly to the
You
person.
can go directly
Okay.
to that
Which-
person.
but three's a crack.
Yeah.
Gotcha.
Got it.
Gotcha.
Okay.
Does that
I was
make
just
sense?
trying to understand what's
Yes.
appropriate in that aspect.
Yes.
Everything else, I
Right.
I'm
But what
aware
I
of.
was envisioning that you're talking about is as a group, before you're here, you're
Yeah.
all talking about your slate.
Got it. No.
That's
that
a
wasn't-
no-no.
Yeah.
Okay.
But if you want to put up Greg, you want to call him and say, Greg, I really want to put your name up as chair. What do you think about that? And he's going to go, no way.
Okay. All right.
And you
That's,
say, okay.
everything else is
Um,
crystal clear.
Could you talk a little bit about the board's role? And the only way I can think to put it is design input. So an applicant comes and they're gonna build whatever it is, and, we kind of would like different trees over there, or, that kind of stuff, where we're,
You only have design input if there's an ordinance provision about design.
okay.
And
So-
your ordinances should be, and your input should be very objective. I mean, if you have an ordinance that looks like it's a little too subjective,
Mhm.
it's probably not appropriate for you to
Right.
be putting in, we think your shutters should be blue.
Right.
Is really not your role. I mean, your role is to follow the ordinance provisions. If there
Right.
are provisions about design, they should be pretty objective. The idea is that an applicant should know what he or she needs to do in order to meet the ordinance by just reading the four corners of the ordinance.
Right,
And not by what your opinion is.
okay.
Having been in all your shoes and in that situation, being an engineer myself, what often would happen is that I'd often have to say, personally, I don't agree with this, but it meets the letter of the ordinance.
Right.
Then the next conversation would be with the planner or the staff saying, that's a little weak, we should, look at amending that or changing that.
Right.
Can we look into doing something with
Right.
that?
But our role is, again, whether we like blue flowers or red flowers,
Right.
Exactly.
we're not there to get into that. We're
No.
there to say, we require screening, you've provided screening.
Exactly.
You might say, you've got all the trees, you want to use a natural buffer and all the trees are 40 feet tall. It would be appropriate to say, geez, maybe we need some lower vegetation because it's not a screen because the trees are so big.
Yeah.
Right.
That's appropriate.
That's
But then
fine.
to say, but I want X species, that might be pushing the envelope too
Okay.
far.
The other thing that comes up occasionally is, and I think I know the answer to my own question, is future use. In other words, well, what if, the property got sold and then we said you could do that? We're only here to judge what's before us today,
Mhm.
period.
Yep.
Whether they're in business, gonna go out of business, or it's not a relevant issue to us, correct?
Right.
And if there's a change of use, obviously that comes back to the code enforcement officer and he has to make a determination whether based on our ordinance, if it's enough to warrant to come as a staff review or a full board plan review, if it's de minimis, if it's a plan revision, if it's amendment, all that's spelled out in our ordinances. We just went through that a couple of years ago. All those layers are in there and what the appropriate review would be, but it would come back at some layer of review.
Okay.
They just can't, and the other thing too is that you can't approve a future use without going through.
Right.
I mean, they oftentimes you see that, somebody will put a dash line, I want to put a future addition here. Well, either you do it or you don't. You don't
Right.
have the ability to say, yeah,
Right.
okay, that kind of makes sense now. It's either on the plan or it's not.
Right.
Unless they want to do a phased approach.
Okay. The other thing I'd like to chat a little bit about is we do a lot of applying conditions, and then there's the waiver, okay? And it's my experience here at the board that we really do try to work with applicants. We're not here to say the letter of law is this, so that's that. It strikes me as we put conditions on things that can be deferred to the expertise of our staff, and they will make sure it gets done. So like the structural engineer, for example. And on the waiver issue, I don't know, I sometimes feel uncomfortable that we have so many waivers or so many conditions. I mean, could you just talk in general about that?
Sure. So just the difference between the two, in my view, is a condition is something that, but for performing that condition, you don't meet the standard. So you need to do X in order to meet standard A, right? So it has to be a link. It can't be, you meet everything, but provided that you have blue flowers instead of red.
Yeah.
When that has nothing to do with any of the standards. A lot of boards try to do that, and sometimes they get away with it because it's just like, let's appease the abutter who doesn't like the color of the fence. Let's just condition that the fence is something, and then if the applicant agrees with it. But really, truly, conditions should only be put on an application if necessary in order to meet the standard.
Okay.
A waiver is, you can't meet the standard, so we have to waive it for you. I can't even put a condition on that's going to provide for you to take an action that will meet the condition. A waiver is just, I can't meet it, so I need to be, that condition, that standard to be completely waived.
Well, how about they could meet the condition if they spent a lot more money and did whatever, and then, but we decide to waive it under, I think the thinking is it's too onerous or whatever.
Well, when you have a waiver, you should have waiver standards.
Well, that's what I was just going to look for. I'm
Yeah.
not
Yeah.
sure whether we have. That's one
You
thing
should. And if you don't, we should,
I don't think we do.
we should.
And
I
that's
think
why I
one
kinda-
thing that-
If that's what you're struggling with, that's why, because
That's
you
why,
should have
yeah.
standards for waivers.
And, it just, again, for me, a lot of times, and again, it's a case-by-case basis, but I always then go back to 50,000 feet and say, ooh, but, we did this here, and we did a condition there. What's the difference? Do you know what I'm saying?
I know what you're saying, but my opinion right prior was based on the fact that when I see waivers, there are standards that need to be met in order to waive it, and that's the difference. You meet those standards, you get a waiver, and you don't have to meet that requirement. If you can't get the waiver, you're going to have to meet that requirement, and sometimes
We
you have
actually
to
do
meet
have
that requirement
standards
through a
on-
condition.
It's on page 33 of 1.
I didn't bring my big book because it was a workshop.
There is a section there that does talk about there's 5 pieces that you can determine.
Yeah.
Could you give us where it is in the book?
Page 33 of 140 in the land use.
So it's in
It's under modification. What's
It's
the
under modifications,
section?
Article 8 under modifications.
See waivers.
What does that section have to do with?
It's got net density, net residential density, then it goes into waivers
Okay.
and seasonal dwelling conversions.
Do you have
The
it?
modifications is an
No,
odd
she has a
title for
different-
that
It
section.
is, isn't it?
Oh,
Yeah.
Take it
That's why
over
probably
there.
no one ever looked there. It's kind of buried in there, but
okay, so page 33 of 140, where?
Waivers.
see.
Oh, I
waivers.
see it. 35, okay. Unless it's on 35, see if your book, it's not 33, it's 35.
There it is.
There it is, okay. Unless otherwise specifically, the planning board may grant waivers from the performance in Article 9, Section, grading
Which-
information defines that. The need for this based on unique circumstances, assigned developing, because it not be
It also gets
expected.
into Board of Appeals stuff.
I
too.
remember reading
Application
this.
of the standard
Well,
is not.
in other
requisite.
words, what that is saying is that you can't you can't grant a variance
Oh, I
essentially.
gotcha. And I think you do, maybe you don't realize, but I do believe indirectly you do take into account those oftentimes when we grant these.
Well,
waivers.
see, I feel comfortable when we don't just decide to waive things. Staff gives us recommendations regarding waivers.
Yeah.
But I just don't know where. how
Well,
it
I think
all-
if you apply these, it's going to make you feel a lot better.
Okay. Okay, thank you.
Yep.
That helps me.
Because five under waivers is appropriate conditions are applied.
Yeah. I know. I have one last question is, okay, so we're into a project and it's pretty complex and sometimes we get materials like at the meeting for that discussion. And this is just for me personally, that gets me all nuts because I don't have time to digest what's in those documents. I've been tempted a couple times to say, done, no, because I can't, you know. Yet, some of these applicants have been, you know, we've stretched them out for 2 months and, you know,
Right.
I don't want to say, well, you know, I've got new evidence, I got new stuff, I can't deal with you today.
Right.
I don't
Is
know
the
how to
new
do it.
evidence coming from the applicant?
Sometimes, yep. Yep.
And there is, again, I found it in here when I was reviewing this today, there is a section in the bylaws that talks about when it's appropriate to accept materials. And again, I think the appropriate way to handle that would be if it's something very simple,
Yep.
you as a board can say, typically we don't accept this, but based on, this is pretty straightforward evidence, you can
Yeah.
accept it.
Or could
I think
we-
you always have the right to say, I need more time to review
Yeah.
this,
Or
and I can't
even,
make my decision if I
can the
don't.
board take a 15-minute recess so we can read the
Yeah.
material?
Yep.
Absolutely.
You know,
Yeah.
because sometimes we're trying to digest as we go in the middle. and
No, you
it's-
can absolutely take a break and go read it. Yeah.
Okay. I don't know, that's just me, I need to understand what it is.
Right, but if you have a practice of a hard line deadline for applicants, and if they don't get everything in by the Wednesday before or the Friday before, whatever that drop dead deadline is, if they miss it,
We don't
have to
have
wait.
to accept additional
Right.
materials.
And it's based on where they are too in the process. Obviously, new applicants have to have their materials in much further in advance. If you're in the queue, so to say, we allow a little grace period. And other times we've come to the board because of conflicts with holidays and everything, we said, well, we'll accept that a couple of days late, as long as staff has it by, we've actually put that right on the record. But I do know that sometimes even staff is kind of put into a tough spot where we're getting things, because we're pushing the applicants to,
Right.
you know, we want to move this along one way or another too. And we get them late, and it's always, you know, there's always
Yeah.
pressure on our
And I
side too.
think the
But
board really wants to serve the public. You know, we want to carry out our duties in an expeditious manner, but, you know, I always get this itch that, you know, maybe we didn't consider everything if we're looking at it as we're making decisions.
And again, it probably feels uncomfortable as you as one board member, but like
Yep.
they say, there's no such thing as a stupid question. You can always put it out there for a board discussion.
Okay.
It's, you know, and it's fine. If you become that one board member that questions everything, that's fine, because that's the checks and balances of a full board.
Mhm,
Yep.
mhm. Those were my questions.
Does anybody have anything else for the protocol or procedures? Because I do have one, we have one, I think, Greg, you and I had talked about this one. In our ordinance, we have site plan requirements, and one of those requirements is that anything in the commercial district must comply with design guidelines. But when you read the design guidelines, these are all suggestive, you know. So the board is always put in a very difficult position as to how far do you go with the guidelines. Some board members feel that if we really want to have these kind of regulations, they should be standards, not guidelines. And it puts them and me in a very difficult situation. So we're starting to face this as we're seeing growth happen again. And
Yes.
for one thing, I think some of the board members I do too, feel like these may be a little bit outdated
Well, and I also.
or lack a little flexibility.
And my read on them is they're not musts. They're totally discretionary
Right.
anyway. So, where my position is, then I'm not paying attention to them. It's not a requirement,
Right.
so why am I,
Yeah, they try to defer it to us,
yeah.
which is not.
And I'll tell you, the
Yeah, well-
new Mexican restaurant design, boy, am I getting an earful about that.
Yeah.
Yeah.
In
I'll take a
favor or
look at
against
that.
it?
Against.
Yeah.
Yeah.
It looks terrible, it's
Well,
out
it's
of
not done,
place.
you know.
Well, that's what I keep saying.
Yeah.
Wait till it's finished. Well, how do we, I said, you can go right up to town hall and ask to see the engineer, the plans. It's gonna have landscaping, but,
Yeah, and it only applies obviously to anything in the commercial corridor.
Okay.
So
So
that's
I'll
a-
take a look. I'll look at
Would it
that.
be too vague to say that the board consider the design guidelines in their, making their determination?
Well, we do. It's in our findings of fact that we considered those.
But I mean, you don't specifically held to meeting them.
That's the problem.
Well, I'm gonna there should be something objective
yes. And I don't
tied
think
to
there-
design guidelines. So I'll take a look.
I mean, it gives you all these different examples and everything, and part of it is again, I think some of the board members feel like it really kind of does narrow, tunnel vision you down in some of the features.
Yeah.
But if you wanted to go outside that with some, not a waiver
Yeah.
criteria, but with a little bit of more,
Right. It may be that you have to either forego them or rewrite them.
Right.
Because you can have objective design criteria about, wall lengths and
Oh,
fenestration
I worked for a
and
town-
permeability and all those kinds of
Yep.
terms.
I worked for a town that actually had ordinances about the external structure, building materials,
well, so does this.
in terms of wood, and you had to use shingles,
Yeah.
and it had to be,
This does exactly that.
and
The
this
city
is
of
what you
Portland
have
has
to do.
Portland has really extensive design guidelines, but they can be applied objectively. I mean,
Yeah.
there's some parts that are a little squishy, but for the most part, it's about they're not telling you, how to what your building. They are telling you what your building should look like, but it's more about forms and mass. It's massing,
Yeah,
forms,
'cause-
permeability, blocks.
Yeah, it gives
that
you an
kind of thing.
opportunity to be different
Creative,
styles
yeah.
and creative, where this one doesn't really offer you that. You're kind of stuck
Yeah.
with one
Right,
style.
right.
And I think that's somewhat difficult because we're seeing, some nice architecture and some opportunities, but this is saying it's got to be a certain charm or a certain type of village appeal, and it may not
Yeah,
totally
it just may be
contrast.
time to revisit that.
I think so.
Yeah.
But I know there was a lot of extensive work put into
Well,
that.
when I was
How old is it?
involved with it,
I think the last,
It-
2009.
it's just the way they wanted it,
Right,
just
Yeah.
the way it is.
yep,
Yeah.
Nothing specific, just consider them.
right.
Yeah.
But it becomes, like you said, though, then it becomes hard to, how do you use that? Then if you really want something changed and they're subjective, how do you?
You can't deny a
you
project.
can't
based
deny a
on that.
project for it, and how do you strong arm an applicant?
Well, see, that's
Right.
exactly what it gets down to for me.
Yeah.
It's not, you must do this, you must do that, so
Right. Then it's not worth even having the conversation.
that's what I
Right.
think.
So that seems to be one that we're running into a little bit.
All right, I'll
and-
take a look.
Okay. Other than that,
I don't know if I
Don't-
have those. Can one of you send me those design guidelines?
I can email
Send
it to
them?
you.
Yes, please. And the requirement to meet them is in where?
it's in the site
language?
plan
The site plan?
ordinance.
Okay.
Yeah, it's buried in there. I'll find it
Okay.
and send you the section.
Okay.
I always, there's like one section here I can never find, and then I have to read it
I know.
four
Just-
times.
It's like socks.
Yeah. Well, it's like the criteria that we actually vote on, it's buried in there, but,
Yeah,
you know.
yeah,
Yeah.
yeah.
So, anybody have any other questions for Mary or myself?
I appreciate it.
welcome.
Just moving on to, if I can, to planner communications. Next month, Scott and I have looked, we've got a application coming in that was, we've discussed this with the attorneys. It was a subdivision that was completed in 2006 or 7. And so it had a DEP associated with that. The DEP approval lapsed, so they've gone back to the DEP. They've made some minor, I don't say minor, they've made some modifications to the road. But however, the plan was recorded, so it's a recorded document. These are lots of record. So the question was, will the town have an opportunity to review this? The short answer is yes, but only on the performance standards that they're modifying.
Gotcha.
Then what will happen is, because we now last year instituted what we call the sunset clause, that these things have a certain time frame and they expire, that will now apply, though, to this subdivision once it goes through.
Once they open it up,
Right.
they open it up to today's standards and rules.
Right, but you're not looking at the lots, you're not changing the subdivision, you're only looking at the performance standards.
We're only looking at what they're modifying as it
Correct.
relates to today's
Or
statutes.
what things may have changed in our ordinance that need to be brought up to speed.
Right, and because
And I will
they,
try to guide you
Yeah.
through that,
since they opened it, they opened themselves to that.
yes.
Okay.
And I will try to guide that with the memo, but just understand you don't, because there's density things and there was elderly densities and things like that that have been wiped off the map in our ordinances, but those are still locked in.
For
Is
that.
that for them? But it's
Gotcha.
just the performance standards that we'll be looking at.
Okay.
And I hope that by then we have some guidance on where they are with the DEP. So that'll be coming in February, and I don't know if we have anything else.
Nothing that's come
I don't
across.
think there's anything else. Tonight, we do have the Mylars for Malibu Drive to sign.
Okay.
There are 4 of us, is that enough? I think it is.
Yeah, if you all voted in the affirmative, I believe it
I
is.
don't think,
You
Oh,
weren't,
you weren't there.
you weren't here.
Yeah.
so-
You can sign it and get the others to come into the office
Yeah.
and sign. We'll do it that way. So I have nothing, if you have any questions for me.
Do I hear a motion for anything else,
Adjourn.
like adjournment?
I motion to adjourn.
All those in favor?
Thank you very much. Thank you, Mary.
Thank you. It's good seeing you.